Hi there. Thanks for tuning in to the Freedom Update. This week I want to tell you about a case that we're involved in at the Supreme Court of Canada that deals with property rights and government expropriation, a topic I find really fascinating, and I hope that you do too. For those of you who are new here, my name is Christine and I'm the litigation director for the charity, the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about issues I find interesting in constitutional law, as well as updates about our ongoing cases. If that sounds like something that you'd be interested in, please hit like and subscribe below. It really helps my videos and my channel out a lot. I also want to remind you all that these videos are not legal advice. They're for your information purposes only. If you have your own legal question or problem, please always consult your own lawyer. So the case that I want to tell you about today is called Annapolis Group and Halifax Regional Municipality, and it's about something called de facto expropriation. Expropriation is when the government seizes private land for a public purpose. And when the government does this, they need to pay the landowner compensation. A de facto expropriation, also known as a constructive or a regulatory taking, occurs when the title to the land doesn't change, but there is in all other senses an expropriation. For example, when the government places restrictions on the use of land without formally taking the property, that might constitute a de facto expropriation. And that's what has happened in the Annapolis case. In Annapolis, a property developer called Annapolis Group owns 965 acres of land in Halifax that are zoned for development. The land is beside a large provincially designated wilderness area, and in 2006, Halifax undertook to create a regional park for the public beside that wilderness area. The proposed park includes the Annapolis land, the privately owned land. But Halifax didn't zone the Annapolis lands for a public park. Instead, they were zoned for future residential serviced development. But development can't begin until it's approved by Halifax through the secondary planning process. If Halifax drags its feet or throws up roadblocks, the land can continue to remain undeveloped and be used as a public park without Halifax having to pay for compensation. And this is what Annapolis alleges has happened here. Annapolis says that Halifax has arbitrarily refused their requests for secondary planning approval, which has kept the land developed for 15 years. They also allege that Halifax has promoted their privately owned land as a public park, including by allowing trail signs to be posted with the Halifax logo on them. So I think it seems pretty transparent to a lot of observers that Halifax is intentionally refusing to allow development and simultaneously encouraging the use of the Annapolis lands as a park because it means they can obtain a park for free. They even seem to have admitted as much. The Halifax Regional Municipality Charter requires the city to acquire lands that it zones for future public use within 1 year. But a public Q&A document about the park development, which is still posted publicly on the internet, stated that, to quote, "The reason the privately owned lands were not zoned regional park at the time of the adoption of the regional plan was because, as mandated by provincial planning legislation, Halifax Regional Municipality would have been required to purchase the subject lands within a 1-year time frame." So they're essentially saying we didn't zone this land as a park because we didn't want to pay for it within that 1-year time frame. And now the land has continued to sit undeveloped for more than 15 years. Now, you would think that this would constitute what I described earlier as a de facto expropriation. The city has used its power to obtain the benefit of a park without paying for it, and they've caused the private property to languish in a completely undevelopable state for 15 years, purposely refusing Annapolis's attempts to develop the property. But the Nova Scotia Court of Appeal held that Annapolis didn't satisfy the currently highly restrictive test for de facto expropriation. Now, that current test for de facto expropriation is laid out in a 2006 Supreme Court case called Canadian Pacific Railway in Vancouver. To prove de facto expropriation, the current law under Canadian Pacific Railway requires the claimant, in this case Annapolis, to show two things. First, that the government has acquired a beneficial interest in the property or flowing from it. And second, the removal of all reasonable uses of the property. Now, this second part of the test is incredibly high. It's so high that it's really inaccessible in cases even where a casual observer can see that an expropriation has occurred. And that's the case here in Annapolis, in my opinion. The Court of Appeal held that despite Annapolis's argument that Halifax had encouraged the public to use their private property as a public park, the city hadn't acquired a beneficial interest. And they also held that Annapolis's reasonable uses of the land hadn't changed. Now the case is going to the Supreme Court, and the Supreme Court is going to consider whether this highly restrictive test coming from Canadian Pacific Railway should be reformulated. Now, we at the Canadian Constitution Foundation are intervening in that case with a new proposed test. In our view, and what we'll argue at the Supreme Court, is that a de facto expropriation takes place whenever a government action results in a fundamental deprivation of the enjoyment of the attributes of ownership. And we argue that there are two really distinct ways that this can happen. First, by denying the owner the right to exclusive possession. This is when an owner of an exclusive property interest has been permanently or indefinitely denied access to the property, or where the government has permanently or indefinitely occupied the property. De facto expropriation can also occur a second way by denying the owner's right to the beneficial use of the property. And an owner who's left with only notional uses of property, none of which have any economic value, we argue in most cases will be denied the right to beneficial use of the property, and a de facto expropriation should generally be found. Adopting our proposed test would change the standard for de facto expropriation, which currently has a really exceptionally high bar. The test that we're proposing would provide better protections for Canadians' property rights, which lack constitutional protections of property rights, something that many other countries have, and our test would better preserve property rights as a foundational principle of liberal democracy. The case is taking place on February 16th at the Supreme Court, and you can live stream it at the link below. I'm also going to be posting it in the description. So if the work that we do at the Canadian Constitution sounds interesting to you, please subscribe to our Freedom Update email at theccf.ca/freedom updates. You'll get regular updates about our work, and of course, you should always like and subscribe to our YouTube channel so you never miss a video freedom update. Okay, that's all for this update. Thanks for tuning in, and let's keep fighting for freedom in Canada.